Hello. Thank you so much for joining. My name is Maggie Sullivan. I'm a coordinator at Foley & Lardner. I'm pleased to welcome you to today's webinar conference on recent developments you should know about patent subject matter eligibility. Before we begin today's presentation, I'm going to go over a few housekeeping items. Today's program will last approximately 60 minutes, followed by a question and answer session. If you experience any technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designed with question mark icon. This PowerPoint presentation will be available on our website at foley.com in the next few days, so you can obtain a copy of the slides via the resource list widget. Foley will apply for CLE credit after the program, wherever applicable. To be eligible for CLE, you will need to be logged into ON24 for the full duration and also answer a polling question with a 5-digit course code, which will be announced during the program. If you did not supply your CLE information upon registering, please email it to myself at msullivan@foley.com. Those seeking Kansas, New York, and/or New Jersey CLE credit are required to complete the attorney affirmation form, in addition to answering the polling question that will appear during the program. A copy of this form is also available via the resource link widget, and please include the 5-digit course code on your completed form and email it to me immediately following this presentation. Certificates of the attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. Now I'd like to introduce our speakers today. With me I have Dan Rose, Paul Hunter, and Courtney Brinkerhoff. Dan Rose is a senior counsel and intellectual property lawyer based in Foley's Boston office, where he is involved in the preparation and prosecution of patent application in the areas of electronics, networking, telecommunications, computer hardware and software, medical devices, and adaptive technologies. He is also a member of the firm's electronics practice and technology industry team. Paul Hunter is an intellectual property lawyer, managing partner for Foley's San Diego office, and chair of the firm's electronics practice. His practice covers a wide range of legal and business issues relating to electronics, computer hardware and software, artificial intelligence, machine learning, semiconductor, memory, and other such fields. Courtney Brinkerhoff is a partner and intellectual property lawyer based in Foley's Washington, D.C. office, where she works with clients in diverse industries, including pharmaceuticals, human and animal food products, nutraceuticals, and medical devices. She's a member of the firm's chemical, biotechnology, and pharmaceutical practice, appellate practice, and life sciences industry. And with that, I'm going to turn it over to Dan Rose, who will introduce the topics.
Thank you, Maggie. Thank you, everyone, for taking the time to be here with us. Hopefully this should be interesting and not too tedious. Primarily, we're going to be discussing the new subject matter eligibility guidance under 35 U.S.C. 101 and the claim interpretation guidance under 35 U.S.C. 112, including an analysis of several eligible and ineligible claims. We're also going to talk about drafting tips for compliance with the new guidance that hopefully should increase your chances of obtaining valuable patents. And we'll also talk about how the guidance applies to the pharmaceutical and personalized medicine industries. So first, as mentioned, the USPTO issued new guidance on subject matter eligibility and interpretation of computer-implemented functional claim limitations in the Federal Register on January 7th. And they've been training examiners on the guidance, particularly in art groups that deal heavily with software-related inventions. Although the guidance is not binding on the federal courts, it is consistent with recent case law, and so we're hoping to see some favorable decisions referring to this guidance in the near future. I can report that in many cases, examiners have been withdrawing subject matter eligibility rejections over the past couple of weeks. So the OneonOne Guidance memo provides explicit categories of abstract ideas that claims must fall into in order to be rejected: mathematical concepts, certain methods of organizing human activity, and mental processes. And the guidance also establishes a more explicit exception for claims that integrate an abstract idea into a practical application. The 112 guidance memo follows the Federal Circuit's decision in Williamson v. Citrix and focuses on claim interpretation of means plus function claims under 112F, as well as written description and enablement support under 112A and B. So starting with a brief review of subject matter eligibility, the Supreme Court established a three-step test in Mayo v. Prometheus and Alice Corp v. CLS Bank. Step 1 asks whether the claim is directed to a statutory category of a process, machine, manufacture, or composition matter. Step 2, which is sometimes referred to as Step 2A, asks whether the claim is directed to a judicial exception. If it is, then Step 3, which is sometimes referred to as Step 2B, asks whether the claim includes additional elements that amount to significantly more than the judicial exception. Under Step 2A, examiners are asked to identify whether a claim is directed to a concept that has been identified as an abstract idea. These concepts include fundamental economic practices, certain methods of organizing human activity, mathematical relationships or formulas, or an idea of itself. And this last category is particularly problematic as it's poorly defined, and it's really very difficult to argue that a claim process or series of steps is not an idea with no concrete form. The new guidance actually drastically simplifies our lives by shifting these categories around somewhat. In particular, the fundamental economic practices category is merged with the organizing human activity category. There's a separate mental process category that's been added, and the problematic idea of itself category has been effectively removed. Additionally, the guidance splits Step 2A into a two-pronged process. First, the examiner asked whether the claim recites an abstract idea in one of these three enumerated categories, and if not, the claim is eligible and no further analysis is needed. We can stop there. If the claim does recite an abstract idea, then under prong 2 of Step 2A, the examiner is asked if the claim includes additional elements that integrate the abstract idea into a practical application. Step 2B is still applied if both of these questions fail, so that provides a third potential path to eligibility.
Thanks, Dan. The Category 1, as outlined in the new guidelines, is defined as mathematical concepts. The guidelines say that these mathematical concepts can be mathematical relationships, formulas or equations, or calculations. The guidelines include footnotes to a number of cases that are very familiar to people that are familiar with 101 case law, including the Bilski case, SAP, Diamond v. Deere, Parker, and Digitech Image Text. You can see on the slide that each of these cases, the court referred to the claims as relating somehow to a mathematical formula. I think it's more helpful to look at some of the specifics of these cases. In the next slide, we'll see claims from three of the different cases. In the upper left is one of the claims from the SAP America case. And in bold, you can see there that the claim requires generating a distribution function using a resample statistical method and a bias parameter. The court in SAP America decided that because the claims were directed to the mathematical aspects of a distribution function, that the claim was really directed to a mathematical concept and not to any kind of technical advance. Similarly, if you look on the upper right-hand side, the Digitech Image Technology case, which is another case cited in the footnotes, the claim here is directed to a device profile that really only claims data for a transformation and a second data for transformation. And in this case, the court held that the claims were merely directed to mathematical formulas and mathematical relationships. Finally, at the bottom, you can see the Bilski v. Kapos claim. The Bilski case related to a method for managing risk, a hedging function, so to speak. And you can see in the claim limitations here are directed to transactions at a first rate and then another transaction at a second rate. Again, the case there, the court held that the invention that was being claimed was directed to mathematical relationships. It didn't relate to any kind of improvement on technology. Now, the second category is the category that we're seeing in the last couple of weeks since the guidelines have been implemented as the most popular one that examiners are going to, and that is certain methods of organizing human activity. Now it's interesting to note that this category gets applied even though the claims may be recited as being directed to not human activity but computerized activity. Some of the footnotes that are cited in the guidelines refer to other cases that are very familiar, like the Alice case, the Bancorp case, and the others that are on the slide. The idea, it seems, from this category is that anytime the claims relate to finance or economic principles or advertising or marketing or managing interactions between people, that the examiners are supposed to label those claims as being methods of organizing human activity. I think it's instructive to look at some of the examples of the cases. We have two separate claims on this slide. The first on the left is from the Bed Bath & Beyond case that related to a claim directed to having a different payment processing depending on whether the purchase is being made by a point-of-sale buyer or a remote buyer or remote seller. And in this case, the Bed Bath & Beyond case, the court found that even though a computer or device, a point-of-sale system was being used, that ultimately the claim was really being directed to how the payment system was being organized, and that regardless of whether devices were used, that the system was directed to how the sale was being organized. Similarly, in the Hulu case, which has the claim on the right-hand side, even though this claim has a total of 10 steps that are labeled that way, the court characterized the claim as a way of distributing copyrighted material over the internet and an arrangement for how the material is presented, where the viewer doesn't have to pay anything in exchange for viewing an advertisement. And again, the court, like in the Bed Bath & Beyond case, found that any technology that was related to the inventive concept here was secondary and not directed to the main focus of what was going on. And because the method was directed to a process of organizing something that could theoretically be done without a computer, the court found that it was not eligible for patenting. The third category is mental processes. These are claims where the concepts are performed in the human mind. The case that often gets cited here is the intellectual ventures case that where the court said there was nothing in the claims that prevented them from being performed by human, either in their mind or with pen and paper. There are a number of other cases on the slides relating to other cases where the courts found that what's being recited as the claimed invention could be done without the technology, without the computer. This next slide shows examples of the claims that have been categorized in this group. And it's interesting to note here, for example, in the intellectual ventures claim on the left-hand side, that there are a number of components that get claimed. The database is claimed, agents are claimed, but the main focus of the claim is not on the technology, but rather on what were the functional outcome of the claim. This is also shown with the right-hand slide, which is the First Choice Loan Services case. The court characterized this claim as an anonymous loan shopping claim. And again, even though this claim has quite a few technology aspects, including a database, a computer system with multiple interfaces, and the claim is talking about all the things that these technical components do, the court found that that technology was just being used the way it's supposed to be used, and the actual functionality could be done with technology or without technology.
Thanks, Paul. While we mentioned that the fourth category, the idea of itself category, has been removed, it's not completely gone. If an examiner still believes that a claim is directed to an abstract idea that's outside of these three enumerated categories, they can still make the rejection, but only with the written approval of the relevant technology center director. So essentially, their boss's boss. They have to go not just to the supervisor, but all the way up to the tech center director. And the examiners are cautioned that they still have to apply Step 2A, Prong 2, and Step 2B to find eligibility, with the tech center director essentially being a last resort only if the rejection cannot be obviated in some other way. And so while we can't say yet how often this will occur, it seems unlikely, except in some of the really most extreme cases. For Prong 2 of Step 2A, examiners are asked whether the identified abstract idea is integrated into a practical application. And specifically, examiners are asked to identify any elements recited in the claim beyond the judicial exception, and asked whether those elements integrate the exception into a practical application. And though this may seem similar to the significantly more test of Step 2B, crucially, this prong of Step 2A requires consideration of all of the elements in the claim, including ones that are well understood, routine, and conventional that would typically be disregarded under Step 2B. Now, while we don't have an explicit definition for when a claim integrates an exception into a practical application, the USPTO states that such claims apply, rely on, or use the exception in a manner that imposes a meaningful limit on the judicial exception. So, for example, merely including computer implemented or by a processor in a claim is unlikely to impose a sufficient limit. The USPTO has also provided some example indications of elements that are sufficient to establish a practical application, including an additional element that reflects an improvement in the functioning of the computer or an improvement to another technology or technical field, an additional element that implements the judicial exception with or uses it in conjunction with a particular machine or manufacturer that's integral to the claim. So again, not just merely saying computer implemented, but have the computer actually have aspects that are central to the claim. And finally, an additional element that affects a transformation or reduction of a particular article to a different state or thing. And the guidance also cites several cases with eligible claims that would meet this practical application test, including applying a natural relationship by immunizing patients in Klassen and Vanda, implementing an abstract idea with a particular machine, such as an idle process, affecting a transformation or reduction of a particular article to a different state, as in Deere and the rubber vulcanization process, or applying the abstract idea in some other meaningful way, such as in Deere and Fingen and Core Wireless. They also identify several counterexamples with cases that would fail to meet this test, such as claims indicating that a function is performed, such as creating and maintaining electronic records, is performed by a computer without actually specifying how that function is performed, or limitations of obtaining information about credit card transactions so that they can be analyzed without going into what the analysis is or the actual steps there, or just field of use limitations, as in Bilski or Fluke.
So one of the questions that we're asked quite a bit is, are the guidelines a change? On the one hand, the guidelines refer and reference to many cases that we're very familiar with. They use much of the same language that was used in the prior guidelines, and for the most part, a lot of attorneys look at the guidelines as just being maybe a rearrangement or reorganization of the categories that were previously used. As Dan has explained, there's no more idea of itself category. On the other hand, though, just by virtue of the fact that the guidelines were issued, it's certainly a signal that the PTO intended for these new guidelines to reflect a change, at the very least to try to have some uniformity among the examining corps of how cases are examined in 101. In practice, we can certainly tell you that we are starting to receive a number of reversals, a number of cases that were going back and forth with 101 rejections that are now examiners are withdrawing the 101 rejections. Also recently, the Electronic Frontier Foundation started a petition for people to sign and the idea is to submit along with the comments to the guidelines that the new guidelines are a violation of the Alice case and will result in going back to the days of unfettered software patenting that the EFF thinks the courts and the legislature wanted to avoid with many of the recent decisions and the new law. Certainly, the last aspect of the guidelines, the practical application, is a new shortcut to eligibility, and I think the effort with the practical application is to address the court's preemption concerns. And Dan's going to go through some examples of how claims can be drafted to overcome this. And I guess one question that I have for you, Dan, is, in your opinion, do you think that the new guidelines is a change?
So thanks, Paul. I would say it's not really a huge change in that, as you mentioned, all of the cases that have been decided would come out the same way, essentially, under these new guidance. It might take a slightly different path to get there. Frequently, what we see in a lot of the Federal Circuit decisions are that they're finding claims eligible under Step 2A as not directed to an abstract idea, while examiners tend to lean on Step 2B if they're going to find a claim eligible and say that there's something significantly more there. But in both cases, both the courts and the examiners are looking for something that provides an improvement to one of these areas of technology. And so while they take a different process to get there, I think both of those come down to whether the idea is actually implemented or applied. And so that actually turns to our first suggestion for drafting and for getting claims that will probably be considered eligible. And that's to focus on the technical aspects of the invention rather than just the beneficial end result. Specifically claiming how the result is achieved rather than just the problem that's to be solved is enough to actually apply these abstract ideas. One way to look at it is almost if you've got a claim that just recites the solution without the steps to get there, it's almost the same as claiming a problem and saying solve it, but the claim doesn't actually get into the application of how that solution is done. So by focusing on these technical aspects, there will at least be sufficient steps in there that apply these ideas in a practical manner. So a claim that only recites the inventive abstract idea without these implementation steps probably will be ineligible. And the USPTO provides some examples. And one thing I like about these particular examples is that they provide both the original claim and a modified claim that would be eligible. And so here, example number 35, this is directed to a hypothetical claim for conducting secure automated teller transactions. And the claim at the left, under the new guidance, this would probably be considered, it could be thought of as both mental processes or methods of organizing human activity. Because even though processors recited in the claim, aside from that, the simple comparison steps and the determining whether a transaction could proceed are essentially just mental processes. They could be done in the mind, and if you read the term processor broadly enough, originally it was actually referring to a group of people doing manual calculations, then this really is a claim directed to mental steps. On the other hand, on the right is their version of a hypothetical eligible claim. And what they've done is expanded this with these 4 additional steps in blue that actually go into the technical aspects of how the processor does the comparison step. And these technical implementation details that are recited actually provide the practical application that goes beyond this mere mental process of just comparing the information. As another suggestion, insignificant extra solution activity really can come out sort of either way, as either a practical application of an idea or just be disregarded. And in particular, data gathering steps are probably not enough. The claim has to actually recite what you do with the data rather than just how you gather it. The comparison here, Mayo v. Prometheus, had a step of administering a drug that was essentially done prior to the inventive analysis that was applied. And the court just considered that extra solution activity, not necessarily post-solution since it occurs before the solution, but extra solution activity, and disregarded it effectively. Vanda's claim includes a similar step of obtaining biological samples and performing an assay on the sample. And if the claim stopped there at that determination step, it would probably have been ineligible also. But it has these 2 additional steps of administering different amounts of the drug based on the inventive analysis, and thus actually applies the idea. Similarly, pre-solution activity is probably going to be more problematic because it's not really an application of the abstract idea because it occurs prior to the abstract idea that is the key to the invention. So data gathering, selecting a type of data to be manipulated, things like that are probably not going to help that much with eligibility. Post-solution activity can really go either way because it depends on what's being done with the information. So for example, the adjustment of alarm limits in Parker v. Fluke, the claim on the left there, was considered just extra solution activity that was insufficient for eligibility. Potentially, if the claim had recited an additional step of actually doing something with that alarm limit, such as turning off a heater or otherwise controlling the catalytic process, that may have been more likely to be found eligible and probably would be found eligible under the current guidance. Now, on the other hand, on the right here, Klassen, a step of immunizing a subject based on the results of the abstract idea that involved screening immunization schedules was actually considered a practical application of the idea. PTO has also provided several new examples that came out with the new guidance. In the example shown here, first method of ranking icons is considered ineligible because the ranking steps can be performed in the mind and there's no application of that ranking. So again, even though the claim here does recite determining by a processor, the processor is essentially disregarded and the remainder of the claim can be simply performed in the mind. So they provide 2 different ways to fix this and achieve an eligible claim. On the right, the claim is modified by adding technical features that cannot be practically performed in the human mind and thus isn't directed to the judicial exception in the first place. And the PTO says particularly, the tracking memory allocated to each application is not practically performed in the human mind because it requires a processor accessing computer memory indicative of application usage. And from their perspective, this makes it eligible under Step 2A, Prong 1, and no further analysis needs to be done. The other route that they suggest for fixing the claim is to apply the ranking that's done with this additional step of automatically moving the most used icons to a position on the GUI closest to the start icon. And here they say that the mental process of the determination is applied into a specific manner of automatically displaying these icons, which provides a specific improvement over prior systems. And that results in an improved user interface for these devices. In another example, a method for monitoring traffic data in a network is considered to be ineligible because, again, the comparison step here can be performed mentally, and the fact that the claim recites a network appliance is essentially disregarded at this step. There's also no application of this comparison that's done, so it's not integrated into any sort of practical application. And the way they suggest for fixing this is by adding this additional step of collecting additional traffic data based on the comparison step to this threshold. And while they say this is still directed to the same judicial exception, it can still be performed in the mind, it's now integrated into a practical application because it's limited to this collection of additional data when the initial collection indicates an abnormal condition. And specifically, they say that although each of these data collecting comparison steps analyzed individually may be viewed as mere pre- or post-solution activity, the claim as a whole is directed to an improvement in how the system monitors traffic data. And so they would say that that would be eligible.
So while the guidance on 101 has probably received the greatest headlines, including the use now of 3 categories or 3 groupings, and also this new practical application exception, in my view, the guidance that was issued on 112 may end up being more important to people with computer inventions than the 101 guidance. Really what we see with the 112 guidance is an effort to try to make the examination of these types of claims uniform, because a lot of what we see in the guidance for 112 has already been used by many examiners, at least in the applications that I see. I was already seeing a lot of this. Now, as the slide shows, there are 2 parts to this guidance. The first one relates to computer implemented methods using means plus function limitations. And then the second part relates to the written description and enablement issues for functional claiming. So just a brief review. Before the AIA, 112 paragraph 6 was the section that included the provision for what was called means plus function claiming. After the AIA changed the code, it is now categorized under 112F, and that an element in a claim can be expressed as a means or a step for performing a function without the structure, but the claim is construed to cover whatever the structure, material, or acts that's described in the specification. Before an important case, the Williamson v. Citrix online case, if there was a claim that included the magic words means for or step for, there was a presumption that 112 paragraph F, or before the AIA, 112 paragraph 6 would be triggered. And then there was a presumption that if the magic words were not used, that 112F was not to be triggered. Now, the Williamson v. Citrix case, which was a Federal Circuit case in 2015, involved the claim term distributed learning control module. So notably, it did not include the magic words means for or step for. And the Federal Circuit overruled the strong presumption that claim limitations without means are not subject to 112F. And in the Williamson case, we did not have a claim limitation using the magic words means for. Nonetheless, the court here found that a substitute term, a nonce word, or a generic placeholder could fulfill the role of what means was playing. And on the slide, you can see the different terms that the Williamson case pointed to, including mechanism for, module for, apparatus for, machine for, and more than likely other placeholders would also trigger this treatment, including configure to, or engine, analyzer, or other generic placeholders, and maybe even the term processor could be viewed as a generic placeholder. So the guidance that's given here is that software patents that are written in functional language without specifying how the claimed function is achieved should be interpreted under 112F. And really the guidelines point to these criticisms that software patents typically are written in intentionally vague and broad language, trying to avoid any particular technical component in an effort to get the broadest claim possible. And so the guidance referring to the Williamson case is telling the examiners that they need to trigger 112F. Now, there are a number of reasons why you don't want to be in what I call the world of 112F. The first reason, and this is in the guidelines, it says that if you're being interpreted under 112F, the specification must disclose an algorithm for performing the computer function. Now, they don't define what they mean by disclosing an algorithm. It may be a mathematical formula or a flow chart or something that you can point to as providing sufficient structure. Now, the guidelines do say this statement at the end here that the requirement for the disclosure of an algorithm cannot be avoided by arguing that one of skill in the art is capable of writing software to convert a general purpose computer to a special purpose computer to perform the claimed function. So the argument that, well, we don't have the algorithm in there that explains, you know, how the function is carried out, but a person of skill in the art would know how to do that. That type of argument is specifically indicated as not holding water. The guidance also talks about the written description requirement for these types of claims, and here again, the drives to have more detail, more specificity, and the underlying idea is to try to get away from these broad software patents that provide black boxes and no description of how the functionality are carried out. And so the examiners are supposed to identify within the specification sufficient description to explain how the claimed function is achieved. The enablement requirement under 112B is also important for these types of software inventions, and specifically the guidelines talk about these different considerations for whether undue experimentation is needed.
So turning to some suggestions for drafting to meet these requirements. So fortunately, it's many of the same considerations that we've talked about as for 101 subject matter eligibility. You want to focus on the technical aspects of the invention and not just what the result to be achieved is, but rather how that result is actually achieved. And by including those details, that will provide sufficient disclosure of these algorithms that actually enable your claimed invention, and including at least some measure of those in the claims, not necessarily the entire algorithm, but at least some of the steps that are actually being performed by the computer or by the hardware to achieve these steps, to achieve the solution, will help with eligibility under 101 also. And for an example here, TLI Communications was a case that involved a claim that recited storing digital images when taking into consideration classification information. And it was found ineligible under 101, but would probably be considered invalid under the new 112 guidance. And specifically, the description didn't include anything beyond the single sentence and the one box in the flowchart shown here. The application would have been helped by a more explicit description of how that information was taken into account, and specifically also what changes it makes to the storage process when it's considered. I think going back to what Paul said earlier about the EFF's concerns over these two broad software patents that were coming through the courts, I think the USPTO is trying to signal here that 112 is probably a better avenue for invalidating these patents or addressing them, rather than 101. And 101 was always intended to be a very low threshold for patent subject matter eligibility. As the court said back in Diamond v. Chakrabarty, it's intended to allow anything under the sun that's made by man. 112, however, provides a stronger filter for focusing on the actual implementation of an idea rather than just the idea or the solution to be achieved. And so I think the PTO is trying to signal that that's where they want examiners to be looking and restricting out these claims. And so, I think many of these sort of poor quality patents that were coming through could be addressed this way without throwing a wrench into the works for all software patentability under 101 the way we were seeing things go. So turning it over to Courtney to discuss pharmaceutical and personalized medicine.
Great, thank you. So obviously, most of the new information in the guidance is directed to the abstract idea paradigm and won't apply as much to pharmaceutical and personalized medicine patents, although there are, of course, some claims within the life sciences category that will be said to at least recite an abstract idea, and so will also fall under the new abstract idea guidance. But I wanted to just highlight how the guidance could apply to claims that don't recite an abstract idea in general. So I think the big change that's generally applicable is the revised Step 2A of the Patent Office analysis that now has the two prongs, which is designed to permit examiners to make an earlier decision that the claims are not directed to a judicial exception. And if once they determine that the claims are not directed to a judicial exception, they can conclude that Section 101 is satisfied and go on to the rest of the process and hopefully allow the claims. As was discussed previously, under revised Step 2A, Prong 1 asks if the claim recites a judicial exception, and then Prong 2 asks if the claim is directed to the judicial exception, where you consider all of the claim features, including those that may be well understood, routine, and conventional. One difficulty with applying this new paradigm to the life sciences space is that there are no new life sciences examples. So we don't really know how examiners will apply Prong 2 to life sciences claims that might have raised difficult decisions previously. I think this guidance could be helpful for claims that recite some sort of product that might be related to a natural product, but have something different, like a detectable label. That's a conventional label, so it might not support patentability under a Step 2B analysis, but could support eligibility under this new Step 2A. And I do think that kind of analysis would be consistent with the Supreme Court and Federal Circuit decisions we have. For example, in the Myriad case, the claims to the cDNA that had covalent bonds different or from the genomic DNA were eligible, and the courts didn't have any problems with that. So I think making even a conventional change to a, quote, natural product to obtain a man-made product would correctly be found eligible under this new Step 2A Prong 2. The more difficult questions come with regard to method claims that are being analyzed under the natural phenomena or natural law judicial exception. For laboratory claims or chemical engineering methods or pretty much any method that does not involve a diagnostic decision. I think step 2A, prong 2, could help examiners reach more logical decisions. We have seen rejections of laboratory methods that have nothing to do with diagnosis, but of course the chemicals react according to natural laws, be rejected under a natural law type of analysis, which I don't think is what the court wants to happen. And this new step 2A, prong 2, will help avoid those types of rejections. The difficulty comes with diagnostic methods that the Federal Circuit has interpreted that Mayo decision that I believe Dan went over earlier as really setting a high bar for eligibility of a diagnostic method. Some of the concepts that Dan had mentioned, including the pre-solution activity or post-solution activity or extra solution activity and data gathering, all of those come into play with the court not giving weight to other features recited in the claims. And we've seen that come up in the Sequinum decision. That was the first major diagnostic decision after Mayo. And then later a Cleveland Clinic decision. And then more recently this week in the Athena decision, where the court is really looking for some sort of technological difference in the diagnostic method versus just I shouldn't minimize the innovation with a just, but if the invention lies in identifying a new marker for a disease, the court's not going to find eligibility, even if you have a lot of concrete steps to implement that knowledge, unless the concrete steps are not well understood, routine, and conventional. So I think here the courts might not follow this prong 2 analysis because they do want the additional elements to be not well understood, routine, and conventional if they're going to support eligibility. It's also important to keep in mind that under this new paradigm, it is possible still to be found eligible at step 2B. That sounds kind of counterintuitive because step 2A, prong 2, is going to consider more factors. So how could you not be eligible at that step, but then be eligible at step 2B? And this is where the examples say that data gathering steps or other steps that might be an extra solution activity could support eligibility if they are, not well understood, routine, and conventional. So this is going to be the circumstance where you have some more technological innovation combined with your natural law related discovery, that together you could be found eligible. So it's important to keep all of these possibilities for eligibility in mind and continue to present claims that focus on just different aspects of the invention and maybe claim it from different perspectives to maximize the chances of being found eligible. I think we're ready for the poll question.
Fantastic. Alrighty. At this time, I'm going to read the CLE code for this program. If you are in need of CLE credit today, please enter the 5-digit code into the poll question on the screen after it is announced and press the submit button. The code is as follows: N as in Nancy, Q as in Quebec, C as in Charlie, B as in Bravo, A as in Alpha. Again, that's N, Q, C, B, A. If you're seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. It will remain open briefly. And again, for those seeking Kansas, New York, or New Jersey credit, in addition to the polling question, you will need to complete the attorney affirmation form and return it immediately after the program. A copy of the form can be found in the resource list widget. Those come in. Just 10 more seconds. Okay, and with that, I'm going to turn it right back over to our speakers.
So Dan, do you want to address some of the questions that we received on the system?
Yep, absolutely. And we still have time if anyone has any additional questions. This first question is, under the new guidelines, claims are too narrow and thus easy for others to design around. And so the questioner asks what suggestions we have to obtain broader claim scope under the new guidelines. And yeah, this is an issue, and there's always sort of a balancing test between trying to get the broadest possible claim that is most valuable for going after your competitors or keeping people out of the marketplace, but balancing that against a patent that's strong and will hold up against invalidity charges. And in particular, I think a lot of this guidance and a lot of the policy that have come out of the courts over the past couple of years is because of a huge number of, frankly, probably too broad patents that were getting issued in the late 90s and early 2000s. And, if you remember, patent trolling was a big item of discussion in the media and lots of places. And I think the court really felt they had to step in to try and stem that tide. And unfortunately, the hammer that they used to pound that nail was 101. And that has caused, a huge number of problems for us since then. I think in the new guidance, the way that the Patent Office is instead focusing on 112 as being sort of a better tool for rejecting these too broad cases rather than 101 is really helpful for us. It doesn't mean that your patent needs to be so narrow as to have your entire algorithm recited in the claim. The claim can still be broader, but by disclosing the specific implementation, it gets down to something that's a little more concrete than just saying, here's a problem, and I'm claiming every potential solution for that problem. And so to get a claim that is, broad scope still under this new guidance, I think at least the specifics do need to be described in the specification. The claim can pull back from that somewhat. We don't necessarily need to go all the way down to specific formulas and things in the claims. But having those details there and actually having something about how the idea is applied to achieve the solution can still give you a broad claim with broad coverage while not being so broad as to be considered an abstract idea or unsupported. Paul, do you have any thoughts on that?
Yeah, so Dan, those are very good comments. I think that if the new guidelines underscore anything, it's the importance of providing a specification that provides at least an exemplary embodiment with details that explain how the invention is carried out. Many times patent practitioners have gotten into the habit of trying to black box, how things are done, and I think it's better for the system to have a requirement that patent applicants, they don't have to describe all of the potential embodiments, but they need to describe the best mode of how the invention's carried out, how the functions are performed, and I think it's going to result in better, as you say, Dan, better claims that are enforceable. Now, these are examination guidelines. We got a question about whether the guidelines apply to the PTAB as well as to the examining corps, and these are they don't have the force of law. They don't bind the courts or the APJs at the PTAB. However, I think that they do provide some very good guidance that I think will help to make examination be more uniform, because I personally have seen very different approaches from different examiners. Some examiners will say, well, as soon as you get over the 103 rejection, I'll just withdraw the 101. And I mean, that's not the way it's supposed to go. We have another question asking how would you incorporate the OneonOne guidance in an offense action now. We are responding to offense actions that specifically cite to the new guidelines and request that the 101 rejection be withdrawn because it didn't follow the new guidelines. And we specifically point out how the claimed invention doesn't fit into one of the three categories. And at least for the first few that I've worked on, since the guidelines became effective at the beginning of January, I have seen some success. I've seen the 101 rejections being withdrawn, although at the same time I've seen 101 rejections withdrawn and 112 rejections added.
Yep. Similarly, I've been responding to rejections coming out either just before the new guidance, in which case they don't incorporate that, and so we refer them to the new guidance, point out how it doesn't fit within the categories, and also frequently how even if it is considered to fit within one of the categories, how the claim recites a practical application of the idea and therefore should pass under the second prong. I've been having a lot of success in those. I think probably, well, certainly the vast majority of rejections that I've had under 101 are being withdrawn, including examiners even calling up and saying that they're withdrawing the rejection and moving to a notice of allowance in many of these cases. So, it's been very helpful. And I think what helps with those cases is where they are written, either post-Williamson or at least with an eye towards that trend in Williamson, and have sufficient disclosure in the written description to support an interpretation under 112F. Like we're just about out of time, and I don't see any other questions coming in, but feel free to email us with any questions if they come up over the next couple of days thinking about this. It's a complicated area of law, and these recent developments are sure to shake things up. But if you do have any thoughts, feel free to reach out to us. Our email addresses are all here on the last slide. And so thank you, everyone, for taking the time today. Hopefully this has been as fun and interesting as we found it.
Thank you so much. This wraps up our web conference today. Just a reminder, today's program is being recorded and will be available on the Foley website in the next few days. At the conclusion of this program, a questionnaire will appear. Please take a minute or two to give us your feedback on the presentation today. It is important to us to know your thoughts and help us shape our programs going forward. And again, if you have any other questions regarding this topic, please feel free to email our speakers or myself at msullivan@foley.com. Thank you so much for your participation.